Good morning to our colleagues and friends who are following this online, and welcome to our monthly briefing, this time bi-monthly briefing, because we will summarize developments during the months of July and August. It is great to have you here with us and our colleagues online. We have quite a few excuses today because the WEF events on the ICT for development, and some of our colleagues are using the last sort of days of holidays for summer holidays. Therefore, we will start immediately with also slightly changed format of the monthly briefings. As you may recall, in the past we used to go through our IG barometer, which you can consult now. What we'll be doing now in the monthly briefings, and we'll appreciate your comments if it is the way how we should proceed, is to identify trends. Therefore, trends that gathered the momentum during the previous month, but seen in the wider perspective of the developments. That's the main focus. And then you can consult, if you need more details, you can consult Digital Watch newsletter or the barometer. This is the new format. We'll start with one question, two questions. The first question, for which colleagues could answer it online, but you can answer it by raising your hands here in the room, is written over there: should cyberspace be considered fourth or fifth military operation domain? The reason is that we wrote in the newsletter, as you can see, that it's fourth military operation domain, and I got quite a few comments arguing that it is fifth. Now we want to hear from online community. You can just click and see the vote, but also from those of you here in the room, could you raise your hands? Do you think that it should be considered as a fourth domain or fifth? First, those of you who think that it should be fourth domain. Now puzzled. There is an answer, no idea as well. What about fifth domain? Okay. Okay, we have the quite sort of confusion around this issue, which exists, and you will see why the confusion exists. And this is another idea of the monthly briefings. We'll try to bring more insights and awareness building around important issues, because you will be hearing fourth, fifth domains in discussion. This is the first question. Arvin, the second one will be much easier, I can tell you. The second question is: should states be responsible for cross-border cyber attacks initiated by individuals and companies based on their respective territories? Should, for example, Switzerland be responsible if some hacker attacks critical infrastructure in Italy? Should it be Swiss responsibility? Could you raise your hands? How many of you think that it should be? Pardon? Well, they will go into this, but now the answer is yes, no, or not sure. Who thinks that Switzerland, in this imagined case, should be responsible for imagined attack coming from Switzerland, from private actors on Italian infrastructure or any other country? Therefore, the answer is yes. Here we have, again, I would say the most of the group, for those the friends online, is that we have no vote, or let us discuss what does responsibility mean. Therefore, there is here still sort of, is anyone voting for no, the Switzerland shouldn't be responsible? We have one vote, shouldn't be responsible for the acts of the private entities. As you already with your questions open the discussion, this is a very tricky question. It cannot be easily simplified to yes or no, and we'll see in a few minutes why it is not the case. We'll continue with the poll, and our colleagues will update you what is the situation, how many votes we have for the fourth or fifth domain, how many votes we have for state responsibility, and it will be open for the few days just to see what the community thinks about these important issues. But now this will be the theme of our first two trends, and you will see why it is sort of controversial, why those are controversial points. Could we have the first slide, please? Here is the list of the activities. Before I go to the trends, you can see that July is very busy. There was the there were quite a few meetings in New York Sustainable Development. There were UNCTAD meeting or E-Trade. I won't go through the whole list because you can consult it. Now we have, as we are discussing, the UNGG group, United Nations Government Group of Experts, is starting their first meeting of the current GG group in New York. Therefore, it is going to be an interesting development. Next. As always, you have a barometers indicating what is the pressure on the specific issues. We are following this trend on global IG infrastructure, sustainable development, security, privacy, and human rights. And you can go through this list, ask the questions, and make a comments on our estimate. Next, please. There is a question of infrastructure, net neutrality, e-commerce, jurisdiction, and Diana transition. As you can recall from our briefings before the summer, we have 10 questions through which we are trying to follow the barometer pressure. Is it increasing pressure, or is it the same, or is it decreasing? Next. Yeah, next one, please. Okay, now we are coming to the 5 trends. The first trend, which is quite important in cybersecurity community, is marked by declaring cyber as a 4th or 5th domain, military domain. This issue is extremely important because it is raising the importance of the cyber security issues on diplomatic agenda. The question is triggered by increasing number of cyber attacks across the national border and vulnerability for the critical infrastructure. The decision was made during the NATO summit, last Warsaw summit in July, and cyberspace is declared as 4th military operational domain at the summit. And the quote goes that in addition to land, water, and air, we have a cyberspace. Therefore, this is the first official document, and we decided to side with the official document. But then in a military academic circles and security and strategic studies circles, there are basically existing 4 domains, and there is a 5th domain. The 4th domain is outer space. The reason why outer space can be mentioned in academic analysis, but not in official document, is that according to the Outer Space Convention, the outer space cannot be used for military activities. It is only allowed to have the conventional weapons, therefore, I guess, a revolver in some of cosmonauts' protest against the captain and their spacecraft. But this is the only type of weapons that can be used in the outer space. This is according to the Outer Space Convention, which is the underlying document like Law of the Sea Convention in the Law of the Sea. Therefore, you will be seeing these 2 rhetorics. One is in academic circles, in analysis as a 5th domain, because outer space is the 4th domain, and in official documents like NATO Warsaw Declaration, cyberspace is a 4th domain. Outer space is not included because it is demilitarized space according to international law. Now you will be hearing more and more discussions about what is the cyberspace. Some of these discussions are philosophical. They're going to the question of ontology. They're going to the deeper question of reality. What is reality? Is a cyberspace collection of our computers and cables? Is there something else in addition, which is the new virtual reality interaction? Now, this discussion has been for quite some time general and I would say more philosophical. Now it is becoming real. Because if NATO declares it as a domain for its military operations, it means that it has to go into the manuals, military doctrine manuals, in strategies, you know, how it is going through the military systems. Therefore, you have to define it somehow. I won't speak about the law, for example. If you say that the crime is committed in cyberspace, to the large extent, it doesn't mean anything. Because is it committed against specific person? Is it done by specific person? Is it committed against the specific computer or server or cables? Therefore, you can expect quite intensive debate in academic and policy circles. What is cyberspace? Some people argue that it doesn't exist. Now, with NATO decision, it's quite a strong and powerful organization. that will be difficult to sustain this argument that it doesn't exist. Therefore, this is the first trend. NATO Warsaw Declaration of the cyberspace as a fourth domain, and dilemma why it exists the fifth domain, because in non-official documents, in academic research papers, you have outer space as a fourth domain, and now cyberspace is the fifth domain. NATO and any other UN cannot include outer space because it is demilitarized according to the Outer Space Convention. We are going to the second trend. For those of you who are, I don't know in what circles you are basically approaching IG issues or digital or cyber issues, in cybersecurity community, the main game in the town is UNGG. UNGG stands for United Nations Group of Government Experts. Therefore, when you go to to meetings of this community, they barely heard of the WSIS or the IGF or other activities. And this is another thing that we should keep in mind. We act in the silos, and in cyber field there are quite a few silos. Therefore, one of the silos, in one of the quite important silos, UNGG, cybersecurity, you have discussion on the treatment of the cyber in the security field. United Nations Government Group of Experts has now 4 groups, and this is the last one, which basically gathered in New York. There were 20, now 25 countries which are members of this group, and they adopted certain principles related to confidence building measures. And one of the most important principles, that they stop discussion if the cyber is different from anything else. They basically declared that existing international law applies to cyber issues. As you can recall, if you have been around in this discussion for, like me, for almost 20 years, initial narrative was that cyber is different, you cannot apply existing law, we have to create a new law. Now UNGG basically said, no, we apply existing law. Now, this statement is important for everybody, for people involved in e-commerce, trade, people involved in telecommunication discussion and other issues, but it is mainly driven by security community. Therefore, they are concerned about the UN chapter, about the question of self-defense, what could be declared as a war, what is this is type of the issues that they have been mentioning. Therefore, they said, okay, cyber, international law applies to cyber. Now, the next UNGG, which started its work today, is going to answer the question, how does it apply? And it is obviously the much more difficult question. Can countries have right for self-defense if they are attacked through cyberspace? Can they use kinetic methods to attack the other country? What about underlying issue, which is state responsibility? As we know, the globe is divided in the national territories covered by national states, with exception of the Antarctic and a few other common spaces. It means that all ICT activities are basically conducted through some physical space. There is a sort of sometimes naive view that outer open sea is not part of national jurisdiction. That's true. The water itself, you can navigate your boat through but any floating object, ship or anything is under a national jurisdiction. If you have a boat which is basically floating in the open sea, that boat is basically under the national jurisdiction of the flag state. Very often Liberia and a few flags of convenience, but it is not outside the national jurisdiction. Now the question is, what happens if you have a cyber attack coming from one territory? Can we ask state, in this imagined example, Switzerland or any other state, to be responsible for attacks that are coming from users on its territory? The views are in the two basically range. On one side, no, state cannot be responsible. On the other side, on the range, yes, states should be responsible for everything coming from states' territory. Now, this view has very practical consequences. if you ask state to be responsible for everything that is coming from the specific territory, you have to give particular states all necessary rights for the surveillance and of the activities on its own territory. Therefore, if you ask state A, Digistan, let's call it that state, to be responsible, the authorities of Digistan can say, yes, we can be responsible for all attacks coming from our territory, but we have to have full surveillance of all cyber activities on our territory if you want us to be responsible. Therefore, this issue in the range between no responsibility and full responsibility is legally and politically quite tricky issue. Now, the UNGG is going to discuss how far one can push state responsibility. There are some legal sources like 2001 draft articles on state responsibility. There is a sort of practice from the climate change community and other communities. And one area which is emerging is that states cannot be responsible for every single attack, but it should be responsible to make all due diligence measures to prevent attacks or to react to the attacks. It should have a strong cybercrime legislation. If there is attack, it should cooperate with the country where the attack is originating in. Therefore, that discussion, I wrote a paper in the preparation for the UNGG meeting, basically mapping the different practices on state responsibility in cyber field. But the gist of discussion will be how you place state responsibility between one possibility, no responsibility, and the other possibility, full responsibility. And probably convergence point can be found around the due diligence measures that state should have. Next. Next question, which has been strongly on the ICT agenda, is the question of linking development and digital. And it was obviously initiated by adoption of the Sustainable Development Goals in September last year. I'm sure that if you're in charge of drafting the speeches for your ministers, ambassadors, you have to include the SDGs somewhere in your speech, because it is becoming one of the mantras of the modern international or diplomatic parlance. Now, institutions started moving to see how to give the substance to that, how to move from the principle, and how to avoid just that it remains one of the notions which all of us have to repeat so many times in our speeches, but at the end, it doesn't affect reality of the people and communities worldwide. And we have a few activities. One extremely interesting report, which I'm sure quite a few of you are aware, is the World Bank report from January this year on bridging digital divides, or the title is Digital Dividends. What the World Bank did, they basically ask questions, is the really impact of digital technology as powerful as we think? And they argued that in many areas it is not. And the question was asked why we don't benefit from all of these possibilities in economic, social, human development, especially in the developing countries. The major answer, and now I encourage you to read this report if you're interested to participate actively in this field, the key answer is that we need analog sort of supplements or analog support for digital development. In other words, we need good legislations, we need good policy framework, development of human resources, which is not necessarily questions related to laying the cables. We still obviously need the cables, we need access, but it is a matter of creating this supplement and environment in which potentials of the digital technology would be realized. Concretely speaking, in July we had a few events. There was UN high-level forum on sustainable development considering the progress in the 1 year. There was also a UN Global Sustainable Development report, where basically they were trying to see how this GHOST SDG, I call it often GHOST 17 SDG, which is ICT, how does it fit into the different silos which are developing of the, 17th, well, I'm lost now, 17th SDGs. Another important activity was initiated by UNCTAD. UNCTAD launched their Nairobi meeting during the summer e-trade initiative, and UNCTAD is trying to approach the question of sustainable development SDGs through this angle of trade and commerce. And you will see in a few minutes how is it operationalized. Next, please. This is the third major trend. The fourth one is e-commerce. I'm sure that you have been hearing a lot about e-commerce potential of the internet, emerging sort of Internet of Things processes, smart cities, and in the same time, questions that countries started developing, fragmenting digital space, and trying to basically, for different reasons, for tax collection, for the development of their nascent industries, digital industries, trying to reduce and somehow slow down the digital connectivity on the global level for different reasons and motivations. Now, World Bank reports again set this trend for discussion on trade development and linking e-commerce, trade and development, these three aspects. And there were a few concrete activities. There was UNCTAD Trade for All initiative, launched in Nairobi, as I already indicated. World Trade Organization collaboration with Silicon Valley players, as Director General of the World Trade Organization went to Silicon Valley. And World Trade is moving much faster in the field of e-commerce. For a long time, it was a dormant issue. There was declaration of no taxation, but now you can see there is much more active e-commerce, the working group, and this is one of the issues, especially for colleagues in Geneva, that you should put in the radar, increasing dynamism in the WTO about e-commerce. Then we have ITU's report, ICT Facts and Figures 2016. This is the annual report that ITU produces, and also trying to map this development, telecommunication, e-commerce aspect. WIPO Global Innovation Index, which addresses the question of e-commerce from the more intellectual property innovation angle. And we have a series of UNCTAD and WTO events. WTO had a MICTA event, and you can see this dynamism is picking up in the WTO community. Therefore, this is a fourth major trend, e-commerce, and the new dynamism on the question of e-commerce in Geneva, in WTO, in UNCTAD. With a slight sort of division of tasks. As you know, WTO is mainly policy-making regulation organization, while UNCTAD has been focusing more on development aspects, and I think this is also an interesting interplay between two organizations. Fifth trend, please. Now, this is extremely important development. Somehow, it was almost invisible in the media. There were few information and few sort of updates. Basically, the transatlantic digital communication is the major digital highway of the global internet connectivity. The most of traffic is going across the Atlantic Ocean, with United States hosting the main internet industry, in particular in Silicon Valley. The major server farms, the cloud, so-called, is hosted in the United States. And on the other side, having the most, sort of, one of the most developed internet market, which is the digital market of the European Union, with more than 500 inhabitants and quite high level of internet usage and penetration. Therefore, what has been going across the Atlantic Ocean is extremely big traffic. We're speaking about Facebook, Instagram, the things that you use daily. Now, the framework for that, the two countries, or European Union and United States, supranational entity, have a different regulations on the question of privacy. Europe has much higher standards in privacy protection and data protection. In the United States, privacy regulation is much more relaxed. Now, what's happened was basically that almost 15 years ago, European and the US officials sat together and said, hey, either you adjust your regulation in the United States to our regulation in the European Union, or we'll have a problem. Obviously, it wasn't possible because the question of privacy is deep into constitution and to legislation in the United States. Therefore, they created Safe Harbor Agreement. Safe Harbor Agreement, which basically argues that data of European citizens will be hosted according to the European regulation on servers in the United States. Therefore, they will be safe harbors in the United States from the otherwise quite relaxed privacy legislation. That worked quite well till Snowden revelation and till the moment when the question of first data and privacy for security reasons and later on data and privacy for economic reasons have become an important issue in discussions. It was triggered by Snowden and security concerns, but nowadays it is becoming more and more the question of the economic use of data. Therefore, one young Australian lawyer basically started the court case in front of European Court of Justice, arguing that safe harbor, Austrian lawyer Max Schrein, he basically won the case, arguing that safe harbor agreement was against European law. The decision to, I can go into legal specificities, but basically it was annulled by European Court of Justice. Suddenly you have the whole traffic going through Atlantic, enormous economic, financial, and user interest threatened that it could be cut, at least according to judgment of European Court of Justice. What has been done, the European Union and the United States have been negotiating extremely intensively the New Deal. A New Deal is a privacy shield. Privacy shield became operational at the beginning of August. It is supposed to replace Safe Harbor Agreement with a stronger and more focused protection of the data of European citizens. Therefore, transatlantic data flow can be continued. So far, it has been sustained the tests and criticism of various organizations, but it is going to remain for economic reasons, not necessarily for security reasons, important issue, and we can expect more and more debates on it. But quick fix, privacy shield is found, and the data can continue flowing over the Atlantic Ocean. We're speaking about very tangible issues that at some point, literally, the access to the Facebook or Google or Twitter could be cut, because if there are alternative ways, but most of the traffic is going through this channel. Next, please. We have other trends. We are going to highlight 5 trends. The other 2 trends, which are emerging and should be kept in mind, is Internet at the center of terrorist threats, investigation following the Nice and Munich attack went to the question of the use of the Internet. Especially in the Munich attack, there was a question of the use of dark web, and it is going to remain an important issue. There is a question of jurisdiction and access to data, again related to this traffic which is going across the Atlantic Ocean. Microsoft challenged the ruling of the US authorities that Microsoft Ireland, not Microsoft United States, Microsoft based in Ireland, Ireland, as you know, is one of the hub for the data and internet industry, should submit, based on subpoena, all data in some investigation about crime to the US authorities. Therefore, Microsoft US Attorney General, I think in New York, issued subpoena requesting Microsoft to submit the data, as Microsoft in the United States should do, according to national law. Microsoft said, wait, we are not Microsoft United States, we are Microsoft Ireland. And then the court case went, and the latest ruling is that it's a landmark judgment. US Appeals Court ruled that authorities could not use search warrant to force Microsoft to turn over user data stored in Ireland. It is a really important development, because then US authorities can approach Irish authorities and through them search for data from the Microsoft Ireland, which is the entity which stores this data. Now, in this dynamic across the Atlantic Ocean, on one side, privacy shield, and we have this court case, we have an interesting development on a possible solution which could ensure the balanced approach to data protection and privacy. On one side, in the United States, privacy shield should provide stronger protection of data. Some criticism was that it's not strong enough. but it's much, much stronger than Safe Harbor Agreement. And on the other side, there is a clear decision by United States Appeal Court that United States authorities, FBI and others, cannot request from the United States companies to submit the data which are stored by their subsidiaries worldwide, like in the case of the island. Next. Okay, here are the few activities in the forthcoming period for the month of September. We'll have a symposium on global cybersecurity in Bern. You will have a global ICT capacity building symposium in Nairobi, I guess co-organized by ITU and few other organizations, discussing how to have global ICT capacity. We have TLD Con in Tbilisi. That's I'm losing my battle to keep with all acronyms, but I'm sure that you can find it somewhere on the net. Internet freedom and constant factor of democratic security in Europe in Strasbourg. That is the Council of Europe event. Human Rights Council will start between 13th and 30th of September. 33rd session, my God, that's sort of so many number threes. If you're superstitious, that could be an interesting sign. But we expect something more on the question of privacy and data protection. We should ask our expert for numerology to tell us what does it mean to have so many trees. And then we have Internet Community 2016. It's ISOC activity on 21st of September. European Cybersecurity Forum 26-27 September in Krakow. 27-29 WTO Public Forum will have a workshop on e-commerce and the sustainable development. There will be so far, I think, noticed 2 workshops dealing with e-aspects of the e-commerce. And there will be Sci-Fi, the India Conference Cybersecurity and Internet Governance in New Delhi, which is becoming the major event in India on the internet issues. India has been, as you probably noticed, this is another trend, gathering more and more visibility in digital policy discussions. They have much more events, they have more academics participating in the conference, and it is also clear trend among actors. There will be APNIC Asia Pacific meeting in Colombo of technical community, and there will be IG MENA for the MENA region, the Internet Governance Summit in Tunis at the end of the month. This is just extract from the really, really busy agenda which you can consult on our events page. But those are a few events that we should keep in mind and put on the radar. Next, please. Oh, well, Diplo, don't miss Pokemon Politics webinar on the 15th of September. It won't be in situ, it will be only online. But you can find it in our newsletter. We are asking questions, what Pokemon game and augmented reality will bring to digital politics? What about the question of the interplay between real and territorial and cyberspace? What about privacy protection? You know that Pokemon has been banned in quite a few countries, and there are controversies in some regions in France. A mayor of one municipality in France, he basically banned the Pokemon because it, according to his view, is endangering security of the kids because once they, well, you know the story, trying to search for Pokemons, they don't pay attention what's going on around them. Then we'll have this session, Inclusive Digital Trade and Sustainable Development at WTO Forum, and we'll have on 27th of September our next briefing, where we will follow these trends and see what is developing for the October. In sum, we have 5 trends which we identified today. Intensify discussion on cyberspace versus real space, becoming very real after NATO decision. Second, what is the responsibility of states for cyber issues? Intensively discussed now in the UNGG group, which started today. Third, the question of sustainable development and cyber. Again, landmark the World Bank report and various activities in the SDG community. Fourth, e-commerce and e-trade in Geneva with WTO, UNCTAD and other players. And fifth, the question of keeping this data highway across the Atlantic Ocean with mainly privacy shield, but also the ruling of the US court on the jurisdiction of the Microsoft Island. I'm now passing the floor to our in situ and online communities. Shall we start with the few questions from online community.
Thank you, Jovan. Our online community has been very vibrant, especially in discussing state responsibility. As you can see from the poll, they are quite divided in whether states should be responsible or not. 15 participants said yes and 9 participants said no. I can highlight some individual remarks that were quite interesting. Karim, who is new to this webinar, welcome. He said that you cannot prevent cyber attacks in your territory unless violating internet freedoms, because it is impossible to control your own cyberspace unless with huge censorship and surveillance. This was a very interesting remark, and it was quite largely debated. And Marilia said that, well, she agreed with you that it depends if the state took all reasonable measures to prevent actors to engage in surveillance, and surveillance would not be reasonable. It also depends on actors' relation to the state, the actors who committed the cyber attack. So yeah, the discussion has been very vibrant. There have not been explicit questions, but a lot of interesting remarks.
The resources of Middle East and North Africa countries and their rapid adoption of digitization have made this region an attractive target for a wide array of cyber threats. Indeed, governments and large organizations in almost every vital sector of the region have sustained damage from cyber attacks. There are numerous cybersecurity threats in the MENA region. Malware is on the rise, and there is a general lack of awareness on how to limit the risk of malware through good security practices. The biggest cybersecurity threat in the MENA region, in the eyes of governments, appear to be cyberterrorism. Some countries have established a strategy to counter terrorism and chose the counter-messaging strategy rather than blocking, such as the case in Tunisia. Cyber warfare is not a dominant threat in the region due to the lack of state-operated cyber weapons, whereas there is a view that such warfares are starting to occur given the rapid increase in internet usage and dependency. About national cybersecurity policies, some countries have created new laws aimed at protecting electronic transactions and prosecuting cybercrimes. Others have established critical information infrastructure protection policies and cybersecurity plans, and have vested responsibility for cybersecurity in existing agencies or directorates. Still others have initiated national incident response protocols and have begun building cybersecurity awareness and capabilities. These are all good steps toward improving national cybersecurity. However, these steps alone, they will not suffice to manage risks associated with the digital assets of an entire country. Most cybersecurity efforts at present are reactive and focus on the role of the government in establishing and maintaining cybersecurity. However, national cybersecurity program must be integrative. It must involve the private sector and citizens. Cyber laws need to be drafted based on multi-stakeholder discussions and not from unilateral decisions by states. I want to highlight the experience in Tunisia, which is an interesting case. Lately, Tunisia has decided to adhere to the Budapest Convention, and a cybercrime law has been drafted and has not reached consensus among different ministries. I quote the Ministry of Telecommunication Technologies and the Digital Economy, the Ministry of Justice, the Ministry of the Interior, the Ministry of Defense, and there are also other institutions involved in this law. This law aims to prevent crimes related to information and communication systems and set the provisions for collecting electronic evidence. The ATT, the Technical Agency for Telecommunication, was created in 2013 to perform legal interception of suspicious online communication. It will have an important role in the provision of technical support for implementation of bills relating to data access and support to the judicial investigations into the information systems of crimes and communication. Today, there's a discussion in Tunisia on how to deal with hackers. Many activists in civil society are pushing to not consider hacking as a criminal act. The current cybersecurity law, which is incorporated in the telecommunication code and is being updated, includes the creation of ANSI, the National Information Security Agency, which accredits, audits, and runs a national security systems. The law aims to set up the different rules to protect information systems and networks and adjust the information systems and network structures, which are subject to a mandatory audit and its follow-up procedures. This law includes many dispersed and diverse texts that lag behind an ever-evolving technology. In addition, we are facing a legislative vacuum between new applications and services like cloud computing. The update of the cybersecurity law will come with a reform for ANSI, which could become the Information System Department of the government, and fix the different gaps in the current legal texts. Finally, I want to add that in Tunisia we are trying to draft policies using the multi-stakeholder process. Unfortunately, we missed the approach, and civil society today is advocating and pushing to correct the shot.
Good morning, Jovan, and good morning to everyone. So, starting with some policy updates here in Brazil. First of all, the Internet Governance Forum, the Brazilian Internet Governance Forum, was organized in Porto Alegre in July, and one of the main outcomes of the forum was the creation of an Internet Rights Coalition that was joined by several academic institutions, by several Internet governance advocates and consumer protection advocates, and the goal of this coalition is to oppose some bills and also some regulatory initiatives that would amend the Marco Civil da Internet and also the General Telecommunications Law, thus reducing the guarantees, the human rights guarantees that these two pieces of legislation are currently protected. Another element that was stressed by the members of this coalition was the concern towards the interim government plan to possibly redefine the configuration and the attributions of the CGI, the Internet Steering Committee, which is currently considered as an example of multi-stakeholder advisory body, which is widely appreciated by the Brazilian society and also considered as a reference by other countries. Another element that was hotly debated over the past 2 months was the blocking of WhatsApp. For the third time in 6 months, WhatsApp was blocked, and for the third time the block was reversed a few hours after having been implemented. And also for the third time, WhatsApp claimed that it was not collecting any data, so it could not be asked to deliver any data, that it is not in its possession. And also Facebook claimed that although it is the parent company of WhatsApp, it does not have any responsibility for WhatsApp behavior because they do not have common activities. This position is becoming increasingly difficult to support, especially after the latest update of WhatsApp terms of service that foresee the data sharing between WhatsApp and the Facebook family of applications by default. So we will discuss here at FGV on 16 September together with the public prosecutor that ordered the blocking of WhatsApp. So we will discuss why WhatsApp has been blocked and what could be the foreseeable outcomes in the future. And on a different note, another event that FGV, the CTS FGV is organized is a workshop on how openness and cooperation can enhance internet policy making. The workshop will be organized on 12 September in Florence at the Internet Science Conference. You are all invited, and the workshop is organized by CTS together with ISOC Italia, also with the Brazilian Internet Steering Committee, the CGI, and also with the French National Digital Council, the Conseil National du Numérique. So you are all invited. And with this update, that's all. Back to you, Jovan, and speak to you next month. Thank you.